Good evening, beautiful people. Thank you so much for joining us this evening. Hope you're having a fantastic day and week. Welcome to our weekly YouTube readings of the final report of the California Reparations Task Force right here on the CJEC YouTube channel. The final report of the first in the nation California Reparations Task Force is one of, if not the most important government reports about the Black American community since the 1960s. Equally important, it's also the foundation for current and future reparations legislation in California. The report is nearly 1,100 pages long, and we're bringing it to you, every page of it, chapter by chapter, every week on Thursdays at 7 p.m. Pacific Standard Time, so that you are properly educated in your advocacy for reparations in California. Today's reading of the final report is presented to you as a community service with support from the Reparations Organizing and Mobilizing Team at the Coalition for a Just and Equitable California, CJEC. CJEC is California's leading grassroots organization born for reparations and reparative justice for Black American freedmen living in California. For more information on CJEC and our work helping to enact the law that created the California Reparations Task Force, California's law requiring state agencies to collect data on descendants of U.S. slavery, the Act to End Current Slavery in California State Prisons, the California Freedmen Affairs Bill, and more, visit www.cjec-official.org. That's www.cjec-official.org. Before we go any further, right now, I ask you to do two things. I ask that you like this video, hit the bell for reminders, and subscribe to our YouTube channel. After we're done reading tonight, I'll ask you to do three more things. Get connected, follow CJEC on all social media, Instagram, TikTok, Facebook, and Twitter, at CJEC Official. Get informed. Visit our website, cjecofficial.org, and sign up for current and accurate California reparations news and information on our Get Involved page. Get involved. Support our work by volunteering and or donating. To donate, just click the Donate tab on the home page of our website. A special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. They are a 501c3. Learn more about the California Black Women's Health Project at www.cabwhp.org. By way of introduction, my name is Raphael H. Plunkett. I live in Southern California. I'm originally from Chicago, and I'm a volunteer reparations advocate with CJEC's Reparations Organizing and Mobilizing Team. Our agenda for today is Chapter 15 of the final report of the California Reparations Task Force. The title of the chapter we're reading tonight is Examples of Other Reparatory Efforts. You can follow along in the reading, download tonight's chapter, or view the final report yourself by going to our website, cjec-official.org/reports. Okay, we're about ready to start our reading, and before we do, I have some special thanks and announcements to make. First, as always, I'd like to thank our good friends at ETM Media Group on YouTube for their live readings of the first California Reparations Report. You can watch and listen to their readings of the first report on their channel at ETM Media Group on YouTube and on our website at cjec-official.org/videos. Second, today's sponsors are my 6 grandchildren, the Plunkett children, Marshall, Takumi, Madison, Marchand, Wataru, and Mallory Plunkett. I, Raphael Plunkett, volunteer with CJEC for my ancestors, my elders, myself, my children, and my grandchildren. Third, for those of you who don't know, historic reparations legislation in California is here, and more is coming. SB 490 is California's first lineage-based reparations-related legislation to establish the California American Freedmen Affairs Agency. The bill was introduced by State Senator Stephen Bradford and will move forward in 2024. To read this bill, visit our website, cjec-official.org/advocacy. Fourth, as mentioned, more historic reparations bills are coming. Over the next several months, more reparations bills will be written. During the 2024 legislative session, we'll see those bills introduced and start moving toward passage by majorities of both the California State Assembly and Senate. To pass reparations bills in 2024, we need 41 Assembly members and 21 senators to say yes. When those bills are passed, we need our governor to sign the bills. So, to make reparations a reality in California, the math is 41 plus 21 plus 1. That's 41 Assembly members, 21 senators, and 1 governor. 41 plus 21 plus 1 equals reparations in California. Lastly, but not least, a special thanks to CJEC's reparations organizing and mobilizing team, specifically our volunteer final report readers. I, Raphael Plunkett, extend gratitude to Chris Lodgson for his focus and leadership. And without further ado, Chapter 15 of the California Reparations Task Force's final report. California Task Force to Study and Develop Reparation Proposals for African Americans. Final report. Read by Raphael H. Plunkett. Chapter 15. Examples of other reparatory efforts. 1. Introduction. AB 3121 directed that the task force address how its recommendations, quote, comport with international standards of remedy for wrongs and injuries caused by the state that include full reparations and special measures as understood by various relevant international protocols, laws, and findings, end quote. The preceding chapter provides an overview of the United Nations principles on reparations and the manner in which those principles have been interpreted. This chapter provides examples of reparatory efforts and special measures that preceded AB 3121 or that are ongoing. Examples of reparatory efforts by other countries followed by such efforts in the United States at the federal, state, and local level. The reparatory efforts detailed below are not exhaustive of those that have been completed or otherwise begun across the globe or elsewhere in the United States. For example, the task force heard testimony from representatives of numerous California localities that are in process of endeavoring to craft measures for the harms and atrocities committed against African Americans who reside or previously resided in those jurisdictions, and the task force is aware of other similar efforts. Also not included here are other reparatory efforts, instances of litigation seeking reparations, and reparatory efforts of private institutions such as universities that played an active role in or otherwise profited from enslavement. The decision to not include these efforts at atonement does not reflect any judgment regarding their value. Many well-intentioned effort to provide reparations has fallen short of meeting the standards set by the United Nations. In fact, it is difficult to point to an example as to which there is universal agreement that the outcome was a model of fully satisfying all 5 of the elements that the United Nations requires for true reparations, namely restitution, compensation, rehabilitation, satisfaction, and guarantee of non-repetition. Some point to the reparations made by Germany after World War II as the example that comes closest to doing so. Interestingly, those reparations were crafted more than 50 years before the United Nations issued its principles on reparations. Many of the programs described in this chapter are thus more properly classified as racial equity measures rather than reparations. A not infrequent basis for this conclusion is where the monetary component of the reparatory effort has fallen short of being commensurate with the nature of the atrocity and the harm that was suffered. A program can also fall short if it only compensates a small number of beneficiaries as compared to the number who suffered the harms. These are just 2 of the more common critiques that can arise. But to one may observe that the efforts given have not met the bar set by the United Nations and still see where there has been value in those efforts. The task force has considered the examples in this chapter, seeking through the recommendations in this report to build on their positive aspects and learn from their challenges and shortfalls. The lessons learned from these examples, as well as witness testimony, public comment, research, analysis, and debate across the task force, have been brought to bear on the full panoply of the task force's recommendations, as set forth in the chapters that follow, all for the purpose of ensuring that the reparations program contemplated by AB 3121 and enacted by California will fully meet the required elements of restitution, compensation, rehabilitation, satisfaction, and guarantee of non-repetition, and provide the justice demanded of the task force and the state. The examples offered below are instructive in one additional regard that bears repeating. As the below cases and others illustrate, our federal government has undertaken reparatory efforts in several instances. Although the outcomes of these programs have been far from perfect, they are an inescapable indictment of the federal government's failure to undertake reparations for the harms and atrocities of slavery and its ongoing legacy. The task force trusts that its work will help spur the federal government to begin to address America's crimes against humanity flowing from enslavement. The Nuremberg Laws were two race-based measures that were approved by the Nazi Party at its convention in Nuremberg in 1935. American citizenship and anti-miscegenation laws, which oppressed African Americans in the United States, directly influenced the Nazi Party in formulating these two laws. 2. International reparatory efforts. Germany, Israel. In September 1952, representatives of the newly established State of Israel and the newly formed Federal Republic of Germany, FRG, met at Luxembourg and signed an agreement that required the FRG to pay reparations to Israel for the material damage caused by the criminal acts perpetrated against the Jewish people during the Third Reich. Although the 1952 Luxembourg Agreement predates the United Nations General Assembly's resolution, which identifies the 5 requirements for a full and effective reparations scheme. The agreement comes close to fully embodying those principles. In particular, its provisions make significant attempts at providing effective compensation for the victims of war and genocide, even though the moral debt for the harm the victims suffered was one that could never, quote, be quantified and would remain eternal, end quote. The Luxembourg Agreement consisted of 3 parts, 2 of which were protocols. The first part of the Luxembourg Agreement required the FRG to pay Israel 3,000 million Deutschmark, DM, or DM 3 billion, to help resettle Jewish refugees in the new state of Israel. The DM 3 billion sum would be paid in annual installments. The second part, Protocol 1, required the FRG to enact laws to pay individual compensation to, quote, former German citizens, refugees, stateless persons, end quote, for harms suffered during the Third Reich. And the third part of the Luxembourg Agreement, Protocol 2, required the FRG to pay the Conference of Jewish Material Claims Against Germany, Claims Conference, DM 450 million for the, quote, relief, rehabilitation, and resettlement of Jewish victims, end quote, of Nazi persecution living outside of Israel. In total, the FRG agreed to pay DM3 450 million, the equivalent of 820 million US dollars in 1952. The Luxembourg Agreement was intended to address the harms inflicted on Jewish people living in Germany or in territories controlled by Germany during the Third Reich, the regime that ruled Germany from 1933 to 1945. Beginning in 1933, the Third Reich implemented several reforms that were intended to control and limit the citizenship and freedom of its Jewish citizens. The Nuremberg Laws were 2 race-based measures that were approved by the Nazi Party at its convention in Nuremberg in 1935. American citizenship and anti-miscegenation laws, which oppressed African Americans in the United States, directly influenced the Nazi Party in reformulating these 2 laws. One of the laws, the Reichsbürgergesetz, or the Law of the Reich Citizen, deprived German Jews of citizenship, designating them as, quote, subjects of the state, end quote. The other law prohibited miscegenation between Jews and, quote, citizens of German or kindred blood, end quote. Other laws were passed which excluded Jewish citizens from certain positions, schools, and professions. For example, Jews were barred from earning university degrees, owning businesses, and providing legal and medical services to non-Jews. Jews were also barred from participating in German social life. They were, quote, denied entry to theaters, forced to travel in separate compartments on trains, and excluded from German schools, end quote. During the Third Reich, the Nazis also confiscated Jewish property in a program called Aryanization. It is estimated that around $6 billion in property was stolen from the Jewish people living in Germany and the territories controlled by Germany. After the war began and Germany expanded its territories, more Jewish people came under German control. The Nazi response was to create, quote, ghettos, end quote, and force the Jewish population to live there until the German government decided what to do with them. Eventually, these acts culminated in the, quote, final solution, end quote, which was the murder of Jewish citizens in concentration camps throughout Germany and territories controlled by Germany. Although there is some debate about when the Nazis decided to kill Jewish people, it is undisputed that, quote, in June of 1941, the Nazis began the systematic killing of Jews, end quote. Just 2 months after his election, Konrad Adenauer, the chancellor of the newly formed FRG, expressed a willingness to address claims of reparations for the harms inflicted on the Jewish people by Nazi Germany. He acknowledged the, quote, unspeakable crimes were committed in the name of the German people, which create a duty of moral and material reparations, end quote. The idea of providing reparations to Holocaust survivors or their heirs of those who died did not begin with Adenauer, however. Beginning in 1949, the Council of States in the American occupied zone established a law of compensation. They implemented a reparations or restitution scheme that was designed to restore to Jewish citizens the property taken from them. By including concepts like the right of displaced people to compensation and the categories of harm that constitute persecution, the laws of compensation, quote, established the foundations of the first nationwide law on reparations, end quote. Discussions about reparations were being held in the Jewish community even earlier, at the beginning of the war. The idea gained support and was discussed at the War Emergency Conference organized by the World Jewish Congress in 1944. In the Jewish community, both in the diaspora and Israel, there was strong opposition to the idea of reparations, however. The opposition was so intense that the head of the Jewish World Congress had to have, quote, clandestine discussions, end quote, with Chancellor Adenauer until they could produce an agreement that would be acceptable to both sides. The Luxembourg Agreement was eventually signed in September of 1952. The first part of the agreement required the FRG to pay DM $3 billion in installments to Israel to help meet the costs of resettling Jewish refugees who fled Nazi Germany and other territories that were formerly under Nazi Germany control. Specifically, those funds provided the means for Israel, quote, to expand opportunities for the settlement and rehabilitation of Jewish refugees in Israel, end quote. Israel invested those funds into its industrial development by purchasing goods and services from the FRG to build and expand its infrastructure. In addition to providing Israel with funds to purchase goods and services, the Luxembourg Agreement required the FRG to ensure the delivery of goods and services to Israel. To ensure the participation of German suppliers, the agreement provided incentives like tax refunds to suppliers, quote, on deliveries of commodities in pursuance of the agreement, end quote. The payments would be paid according to the schedule in the Luxembourg Agreement. The first installment was made in 2 payments in 1952. The first payment of DM $60 million was due on the day the agreement was entered into force. The remaining DM 140 million was due 3 months later. For 1953, the FRG was required to pay DM 200 million. The remaining funds would be paid in 9 annual installments of DM 310 million plus a 10th installment of DM 260 million. After 1954, if the FRG determined that it could not comply with the obligation, it was required to give Israel notice in writing that there would be a reduction in the amount of the installments. But in no way could any of the installments be reduced below DM 250 million. 4 agencies were established to ensure that the agreement would be carried out. The Israeli mission was the sole agency that could place orders with German suppliers on behalf of the Israeli government. But jurisdiction was conferred on German courts to decide disputes arising out of the performance of individual transactions involving German suppliers. The second agency was the agency designated by the FRG to examine all orders placed by Israel to ensure that they conformed with the agreement. The third agency was the Mixed Commission, which was responsible for supervising the operation of the agreement. Its members were appointed by their respective governments. It had no adjudicative power. The fourth agency, the Arbitral Commission, had adjudicative power over disputes between Israel and the FRG, except for those disputes that involved the individual German suppliers. Each country appointed one arbitrator, and the arbitrators, by mutual agreement, appointed an umpire who could not be a national of either contracting party. If the parties could not agree on the appointment of an umpire, the president of the International Court of Justice would select one. The arbitrators served 5 years and were eligible to serve another term once their 5-year term expired. Individual compensation. The second part of the agreement, Protocol 1, required the FRG to enact laws for payment of individual compensation to former German citizens, refugees, and stateless persons. The FRG enacted the first supplementary law for the compensation of victims in compliance with Protocol 1 in 1953. The federal supplementary law covered harms that occurred between January 30th, 1933, the beginning of the Third Reich, and May 8, 1945. Preceding the federal supplementary law was a general acknowledgement of the wrongs committed by the Nazi regime. In recognition of the fact that wrongs have been committed against persons who, under the oppressive National Socialist regime, were persecuted because of their political opposition to National Socialism or because of their race, religion, or ideology, that the resistance to the National Socialist regime, based on conviction, faith, or conscience, was a service to the welfare of the German people and state, and that democratic religious and economic organizations, too, have suffered damages by the oppressive National Socialist regime in contravention of the law. The Bundestag, with the consent of the Bundesrat, has enacted the following law. The federal supplementary law identified the following categories of harm that were eligible for compensation. Compensation for life. Under this category, widows, children, and dependent relatives could apply for an annuity for wrongful death based on the amount paid to families of civil servants. Compensation for health. Under this category, claimants were entitled to medical care for, quote, not insignificant damage to health or spirit, end quote. For damages beyond claims for medical care, claimants could apply for an annuity, but had to prove that the persecution caused certain health damages that led to at least 30% reduction in their earning capacity. Compensation for damages to freedom. This category included claimants subjected to political or military jail, interrogation custody, correctional custody, concentration camp, ghetto, or punishment entity. It also included forced labor, quote, insofar as the persecuted lived under jail-like conditions, end quote. Compensation for property, assets, and discriminatory taxes. Claimants could file claims for the loss of property that occurred because the claimant fled the country, emigrated, or was robbed of their freedom. They were also entitled to compensation for property damage and paying discriminatory taxes such as the Reichsflight tax. Compensation for damages to career or economic advancement. This category entitled self-employed and privately employed claimants from the time persecution began until January 1, 1947. The exact amount would be calculated at 2/3 of the relevant civil servant's pay. If a claimant was unable to resume their career, they could elect to receive their pension early. The amount of the pension was 2/3 that of the civil servant's pension. Those who wanted to reestablish their business were entitled to a loan of up to DM 30,000. Claimants could also claim assistance to make up for their missed education. Compensation for loss of life or pension insurance. The claimant could claim up to DM 10,000, meaning they were not limited to one category when filing claims. If the claim was denied, the victim could file the case in court. For damage to body or health claims, the claimant would have to be interviewed and examined by court-nominated experts. There was some deficiency in the 1953 federal supplementary law, which Parliament tried to fix in the 1956 federal compensation law. The 1956 law increased the maximum compensation for loss of life to DM 25,000 and improved the claims process to make it easier for claimants. In 1956, the law still excluded those persecuted outside of Germany, forced laborers, victims of forced sterilization, and, quote, antisocial, communists, gypsies, and homosexuals. In 1965, the FRG enacted the Federal Compensation Final Law. The final law made the following changes. It created a hardship fund of DM $1.2 billion, or $300 million to support refugees from Eastern Europe who were previously ineligible for compensation, primarily immigrants from 1953 to 1965. Compensation for health eased burden on claimants to prove damages to their health were caused by their earlier persecution by including a presumption that if the claimant had been incarcerated for a year in a concentration camp, subsequent health problems could be causally linked to the persecution under the Nazi regime. The category for loss of life was expanded to include deaths that occurred either during persecution or within 8 months after. The ceiling for education claims was increased to DM 10,000. Claims already adjudicated were to be revised based on the new law. The final law did not include a category for compensation for work performed by slave or forced labor. Over the course of the reparations process, the German government received over 4.3 million claims for individual compensation, of which 2 million were approved. It is estimated that by 2000, Germany had paid more than DM 82 billion in individual reparations, or 38.6 billion in US dollars. Protocol 2, Claims Conference. The third part of the Luxembourg Agreement, Protocol 2, required the FRG to pay the Claims Conference DM 450 million, the equivalent of 107 million US dollars, for the, quote, relief, rehabilitation, and resettlement of Jewish victims, end quote, of Nazi persecution living outside of Israel. The money would be paid to Israel, and Israel would disburse the funds to the Claims Conference for it to disburse the money. Post-1952 Luxembourg Agreement measures. In 1953, 1956, and 1965, compensation laws excluded compensation for forced labor and slave labor. The process for compensating these harms began in the German Parliament in 1998. The World Jewish Congress and the Claims Conference began placing pressure on German companies that benefited from slave labor and forced labor during World War II to pay reparations. These companies also faced foreign political pressure from governments like the United States. There was no political pressure from organizations like the United Nations, however. Lawsuits in the United States against German companies that operated in the United States also applied pressure to the German government and the German companies to provide compensation for the labor they benefited from during the war. These efforts culminated in the enactment of the Forced and Slave Labor Compensation Law in July of 2000. 8 countries were involved: Germany, the United States, Russia, Israel, Poland, the Czech Republic, Belarus, and Ukraine. The fund contained DM 8.1 billion to compensate slave and forced laborers. The compensation scheme implemented, quote, rough justice, end quote. Former slave laborers received DM 15,000 or the equivalent of 75,000 US dollars. Former forced laborers received DM 5,000 or 2,500 US dollars. Payments were limited to claimants only and not extended to descendants. However, heirs of anyone who died on or after February 16, 1999, the date negotiations regarding the compensation began, could file a claim. The law also allowed for compensation for all non-Jewish survivors living outside the 5 Eastern European countries. The International Organization for Migration processed those claims. Claimants had to complete applications by December 31, 2001. By the deadline, the International Organization of Migration had received 306,000 claims. In filing their claims, claimants had to provide details of previous claims and a copy of their IDs. They were also required to declare whether they received slave labor compensation directly from a German company. They also had to identify a place where they were forced to perform slave or forced labor and waive their legal rights against the German government and in connection with Nazi-era activities against all German companies. Every check that was issued under the Forced and Slave Labor Compensation Law had the following apology from the President of Germany included: "This compensation comes too late for all those who lost their lives back then, just as it is for all those who died in the intervening years. It is now, therefore, even more important that all survivors receive, as soon as possible, the humanitarian agreement agreed today. I know that for many it is not really money that matters. What they want is for their suffering to be recognized as suffering, and for the injustice done to them to be named injustice. I pay tribute to all those who were subjected to slave and forced labor under German rule, and in the name of the German people, we beg forgiveness. We will not forget their suffering." Assessments of the FRG, Israel Reparations Scheme. Initially, there was significant opposition to the idea of reparations in Germany. Chancellor Adenauer's reparations initiative did not have the full support of German citizens. Germans considered themselves victims of the war, and the majority believed that German widows and orphans should receive support first, with Jewish citizens at the bottom of the list. Government officials were also against reparations. One concern was that a potentially large expenditure, as reparations would likely require, could be risky for Germany given its financial position after the war. There was also opposition in the Jewish community. This initial opposition was so intense that the initial negotiations were held in secret until they could reach an agreement that would be acceptable to both countries. Underlying the opposition was the idea that the Jewish people should not accept money to absolve the German people of the harm they caused. The debt the Germans had incurred was a moral one that could not be paid off. Pragmatism eventually won. Reparations could help develop Israel so that the country would be stronger and could save Jews from all over the world quickly in another crisis. But it was understood that the moral debt Germany had acquired because of its actions towards the Jewish people could not be, quote, quantified and hence would remain eternal, end quote. Scholars have noted that the Luxembourg Agreement was unique in many ways. It was the first reparations agreement that required a country to compensate another country that was not the victor in a war. Further, it was the first reparations program where the perpetrator paid reparations, quote, on its own volition in order to facilitate self-rehabilitation, end quote. And the agreement was formed by 2 states that were, quote, descendant entities of the perpetrators and victims, end quote. The program was the largest reparations program ever implemented. It had a significant economic and political consequences for both Israel and the FRG. The treaty enabled a substantial trade relationship between two countries. When reparations payments ceased in 1965, Israel and the FRG gradually initiated political relations. Chile. Under the 1973 to 1990 dictatorship of General Augusto Pinochet, the people of Chile were subjected to a systematic campaign of torture and state violence. An estimated 2,600 to 3,400 Chilean citizens were executed or, quote, disappeared, end quote, while another estimated 30,000 to 100,000 were tortured. The dictatorship began with the coup the morning of September 11, 1973, under the guidance of U.S. Secretary of State Henry Kissinger, to seize the democratic socialist government of Dr. Salvador Allende. Pinochet's military junta seized power, ending Chile's long tradition of constitutional government. Pinochet's military dictatorship defined segments of the Chilean population as ideological enemies, the, quote, subversive, unquote, and detained, tortured, and murdered suspected opponents of the dictatorship. According to the 2004 Volokh Report on Political Imprisonment and Torture, at least 27,255 people were tortured from 1973 to 1990, and approximately 2,296 people were killed or, quote, disappeared, end quote, although an additional 1,000 still remain unaccounted for. The National Truth and Reconciliation Commission found 899 additional cases of individuals, quote, disappeared, end quote, or killed by state agents in that same period. In 1988, the national plebiscite or referendum was held to determine whether General Augusto Pinochet should remain president of the country. The plebiscite voted against his continuation. In March 1990, Patricio Alvin was sworn in as President of the Republic of Chile, and 1 month later, he created the National Truth and Reconciliation Commission. This 8-member commission was tasked with disclosing the human rights violations that occurred under the previous dictatorship, gathering evidence to allow for victims to be identified, and recommending reparations in a legal, financial, medical, and administrative capacity. In February 1991, the Commission delivered its first report, the Rettig Report, to the President. The report that between September 11, 1973 and March 11, 1990, 2,298 persons had died as a result of human rights violation or political violence. The Chilean Armed Forces and the Supreme Court officially rejected the report, arguing that it did not take into account the historical and political context in which these acts occurred. Despite such criticism, however, the actual content of the Rettig report was not denied. President Alvin sent a draft bill on reparations for the victims to Congress using the recommended measures of reparations from the Rettig report. The bill was approved and signed into law on February 8, 1992. Law 19.123 established the National Corporation for Reparation and Reconciliation with the purpose of coordinating, carrying out, and promoting actions needed to comply with the recommendations contained in the Report of the National Truth and Reconciliation Commission. As written in Law 19.123, the National Corporation would, but not be limited to, do the following: promote reparations for the moral injury caused to the victims and provide the social and legal assistance needed by their families so that they can access the benefits provided for in Law 19.123. Promote and assist in actions aimed at determining the whereabouts and circumstances surrounding the disappearance or death of the detained or disappeared persons and of those persons whose bodies have not been located, even though their death has been legally recognized. In pursuing this objective, the corporation should collect, analyze, and systematize all information useful for this purpose. Serve as a depository for the information collected by the National Truth and Reconciliation Commission and the National Corporation for Reparation and Reconciliation, and all information on cases and matters similar to those treated by it that may be compiled in the future. It may also request, collect, and process existing information in the possession of public and private institutions in relation to human rights violations or political violence referred to in the report of the National Truth and Reconciliation Commission. Compile background information and perform the inquiries necessary to rule on the cases that were brought before the National Truth and Reconciliation Commission, in which it was not possible to reach a well-founded conclusion as to whether the person detrimentally impacted was a violence of human rights violation or political violence, or rule on cases that were not brought before the Commission in a timely fashion, or, if they are, in which the Commission did not reach a decision due to lack of sufficient information. Enter into agreements with nonprofit institutions or corporations so that they may provide the professional assistance needed to carry out the aims of the corporation, including medical benefits. Make proposals for consolidating a culture of respect for human rights in the country. Law 19.193 also established a monthly reparations pension for the families of the victims of human rights violations or political violence as identified in the report by the National Truth and Reconciliation Commission. The Institute of Pension Normalization was placed in charge of paying the pensions throughout the country. In 1996, the monthly pension amounted to 226,667 Chilean pesos, or US dollars 537. This figure was used as a reference for estimating the different amounts provided to each type of beneficiary as defined in Law 19.123. A one-time compensatory bonus equivalent to 12 months of pension payments was also awarded. A beneficiary would also receive the pension in the proportion determined by the law, even if there were no other beneficiaries in the family. Also, if the amount required by the number of the beneficiaries exceeded the reference amount, each of them still received the percentage established by law. At the time of the passage of Law 19.123, other similar programs were created to remedy specific issues, including a program within the Chilean Ministry of Health, financed by the United States Agency for International Development, to provide comprehensive physical and psychological health care for those who were most affected by human rights violations. There have been public criticisms of the reparations measures implemented by the government. Critics have objected to the declaration of the presumed death of the victims, the creation of a public interest corporation with no juridical faculties to investigate the whereabouts of disappeared detainees, and an unfair single pension model that does not take into account the number of members in each family. There were also notable issues with Law 19.123, which excluded certain beneficiaries, unmarried partners, victims without children, and mothers of children born outside of marriage, and lacked recognition or remedy for the specific victims, those illegally detained and tortured. On December 31, 1996, under new presidential leadership, the corporation closed down and issued a final report declaring that the work of the institution had contributed effectively to political reconciliation, but that the pending cases of more than 1,000 disappeared detainees undermined these efforts, and that some of the obligations assigned to the corporation had not been fulfilled. With these unfulfilled obligations, and with an obligation to continue searching for disappeared victims under Article 6 of Law 19.123, the state continued some of the work of the corporation following its closure. On April 25, 1997, the state issued Supreme Decree number 1.005, which established that a new, quote, follow-up program, end quote, be created to follow up on specific duties and responsibilities of Law 19.123. This included implementation of the recommendations by the Truth and Reconciliation Commission, provision of legal and social assistance for the families of the victims upon request, preservation and safekeeping of documents and archival records collected by the National Truth and Reconciliation Commission and the former National Corporation of Reparations. The next president, Eduardo Frei Ruiz Tagle, continued this work on reparations and initiated roundtables on human rights between 1999 and 2000. These roundtables culminated in a supplementary report of 200 new cases of disappeared detainees. In response, elements of the follow-up programs for Law 19.123 were integrated into the Human Rights Program of the Ministry of Interior. The new program continued to work with families, and a newly reorganized judicial program provided logistical support to special judges conducting investigations in regiments, clandestine cemeteries, and other places indicated in the report by the armed forces. In August 2003, the next president, Ricardo Lagos, proposed and sent 3 bills to Congress to strengthen the work of the follow-up program, increase pension amounts, and expand beneficiary access to pensions. The president argued that the human rights violations of the dictatorship represented a social, political, and moral scar that required additional meaningful reparation measures and a responsible recognition of the magnitude of the problem. In September 2003, President Lagos created the National Commission on Political Imprisonment and Torture Report, the Valtech Commission, to continue the work of reparations by identifying victims, proposing new measures of reparations, and producing a final report. On November 10, 2004, the Valtech Commission delivered its first 1,200-page report to President Lagos, who then presented it to the nation in a televised speech later that month. The president asked the Valtech Commission to produce a complementary report taking into account approximately 1,000 additional cases submitted by victims and their families. The report was delivered in June 2005. In 2005, the Chilean government decided to provide 28,459 registered victims or their relatives with lifelong governmental compensation, approximately U.S. $200 per month, and free education, housing, and health care. In 2009, the Chilean Congress passed law number 20.405, creating the Institute for Human Rights. Under this law, Chilean President Michelle Bachelet was tasked with creating a consultative commission, the Valtech II Commission, for the qualification for reparations for disappeared detainees, persons killed by extrajudicial executions, prisoners of conscience, and victims of torture. At this time, the Chilean government entered into international networks to help address the human rights abuses that occurred in Chile. In 2009, Chile joined the Rome Statute of the International Criminal Court in 2009. In 2015, Chile became a signatory party to the agreement on the status and functions of the International Commissions on Missing Persons. Today, the Chilean government continues to work to address past human rights abuses through new commissions and instruments, including the Chilean system of national DNA databases to test and match DNA samples between relatives and missing persons. South Africa. Quote, apartheid was an institutional regime of racial segregation and systematic oppression implemented in South Africa for the purpose of depriving the majority black population of basic rights and securing the white minority's power over the country's government, economy, and resources. End quote. Following the election of Nelson Mandela as the country's first non-white president, the South African government passed the Promotion of National Unity and Reconciliation Act, the Act, to help transition South Africa out of the apartheid era and into an era of democracy in which black South Africans would have full participation. To make this transition, the Act created the Truth and Reconciliation Commission, which operated through 3 committees. One committee was the Committee on Human Rights Violations, CHRV, which investigated the gross human rights violations committed during the apartheid regime. Another committee of the commission was the Amnesty Committee, which was responsible for determining which perpetrators of gross human rights violations would receive amnesty, that is, immunity from civil and criminal liability for their crimes. And the final committee was the Committee on Reparations and Rehabilitation, CRR, which was responsible for developing an urgent interim reparations program and submitting final reparations policy recommendations to the government. Included in the final reparations policy recommendations were financial and symbolic reparations, as well as community rehabilitation programs and institutional reforms. The financial reparations and recommendation was that the government pay individual reparations grants to 22,000 confirmed victims each year for 6 years. To ensure successful implementation, the CRR also recommended that the government appoint a national body to implement the reparations program and a secretariat within the office of the president or the vice president to oversee implementation. The government adopted some of the CRR's symbolic reparations recommendations, its community rehabilitation program recommendations, and its institutional reforms. The government did not adopt the recommendation for a national implementing body, nor did it adopt the CRR's recommendation that it pay individual reparation grants for 6 years. Instead, in 2003, 5 years after the CRR submitted its final reparations policy recommendations, the South African government paid a one-time payment of R30,000, the equivalent of $4,000 to some of the 22,000 victims. The payment was about 1/5 of the amount the CRR recommended to justly compensate victims for their suffering. By 2004, only 10% of the confirmed victims had received their payment. The history of the apartheid and gross human rights violations. De jure racial segregation was widely practiced in South Africa since the first white settlers arrived in South Africa. When the National Party gained control of the government in 1948, it expanded the policy of racial segregation, naming the system apartheid. The system of, quote, separate development, end quote, was furthered by the Population Registration Act of 1950, which classified all South Africans as either Bantu, all black Africans, colored, those of mixed race, or white. Another piece of legislation, the Group Areas Act of 1950, established residential and business sections in urban areas for each race and barred members of other races from living, operating businesses, or owning land in areas designated for a different race. The law was designed to remove thousands of, quote, coloreds, end quote, blacks and Indians from areas classified for white occupation. As a result of the confluence of laws, specifically the Population Registration Act, the Government Areas Act, and several, quote, land acts, end quote, adopted between 1913 and 1955, more than 80% of South Africa's land was set aside for the white minority. The government also passed laws limiting education for black South Africans, specifically the Bantu Education Act of 1953, provided for the creation of state-run schools, which black children were required to attend. The goal of these state-run schools was to train black children for, quote, manual labor and menial jobs, end quote, the government, quote, deemed suitable, end quote, for their race. Black South Africans were also barred from attending universities in South Africa. To help enforce the segregation of the races and prevent black South Africans from encroaching on white areas, the government strengthened existing, quote, pass, end quote, laws, requiring, quote, non-whites to carry documents authorizing their presence in restricted areas, end quote. Many private companies, including ones based in the United States and Europe, enabled apartheid by manufacturing the military and police vehicles used to enforce segregation and by creating the document system that stripped black South Africans of their citizenship and rights. Responses to violations of apartheid laws were brutal. Under South African law, police officers could commit acts of violence, that is, torture or kill, in the pursuit of their official duties. One confirmed victim of gross human rights abuses was tortured by police on 4 different occasions. On one occasion, he was electrocuted. On another, quote, they put a tire around his neck, placed his hands behind his back, and threw matches at his hair, end quote. On one occasion, he was tortured for 5 days. And on yet another occasion, he was detained for 6 months without charges and tortured. There were also numerous large-scale shooting incidents that involved police officers roaming through black townships in vehicles called hippos and shooting black people, including children. In one incident in 1985, a 13-year-old was shot and killed by security forces while traveling from his grandmother's house to his home to pick up his school books. Other children were shot and killed while playing outside with friends. The Commission's final report documented the, quote, extreme violence necessary to maintain the apartheid regime, end quote. In essence, the system of apartheid was held in place by gross human rights violations, quote, including prolonged arbitrary detention, forced exile, forced relocation, revocation of citizenship, forced and exploited labor, extrajudicial killings, and torture, end quote, committed by state and private actors. There was resistance to apartheid from the beginning. One of the first demonstrations against apartheid took place in Sharpeville on March 21, 1960. As a result of the demonstration, police officers opened fire on the crowd, quote, killing about 69 black Africans and wounding many more, end quote. The primary political group that spearheaded the fight to eliminate apartheid was the African National Congress, ANC. The government banned the ANC from 1960 to 1990. Eventually, there was outside economic pressure on South Africa to abandon apartheid, including from the United States and Europe, which imposed selective economic sanctions on South Africa. Secret negotiations between the National Party and the ruling Apartheid Party and the ANC, the resistance to end apartheid, began under President Botha and concluded under President F.W. de Klerk on February 2, 1990, when he announced that he would release all political prisoners and unban anti-apartheid organizations like the ANC. De Klerk's announcement began formal negotiations to end apartheid. The bargain struck required the NP to give up power and allow free elections in exchange for amnesty. Those negotiations culminated in the interim constitution, which enfranchised black South Africans and provided for elections in 1994. The interim constitution required the new parliament to draft a final constitution and draft the framework for the new government of South Africa. The interim constitution also included an unnumbered section called the Coda, Postamble, or Epilogue, which provided for an amnesty for the outgoing government in exchange for it giving up power peacefully and having the votes of everyone respected. The Coda also included language calling for reparations. Quote, the violent effects of apartheid can now be addressed on the basis that there is a need for understanding but not for vengeance, a need for reparations but not for retaliation, a need for Ubuntu but not for victimization, end quote. Essentially, the bargain struck during the negotiations to end apartheid called for the perpetrators of gross human rights violations to receive amnesty and the victims to receive reparations. Reparations and the creation of the Truth and Reconciliation Commission. In addition to creating the commission and outlining the duties of its three committees, the Promotion of National Unity and Reconciliation Act, the Act, identified the need for reparations as a primary concern, requiring the commission, quote, to provide for the taking of measures aimed at the granting of reparations to and the rehabilitation and restoration of the human and civil dignity of victims of violations of human rights, end quote. It also defined several key terms that would be used throughout the reparations process. First, it defined reparations using a very broad and open-ended definition, quote, any form of compensation, ex gratia payment, restitution, rehabilitation, or recognition, end quote. The Act also distinguished between a longer-term reparations policy and an interim urgent reparations policy that would provide urgent reparations to, quote, victims, end quote. The urgent reparations would go to those, quote, victims not expected to outlive the commission, end quote, and, quote, those who had urgent medical, emotional, educational, material, and symbolic needs, end quote. A, quote, victim, end quote, was defined as a person who, quote, suffered harm in the form of physical or mental injury, emotional suffering, pecuniary loss, or substantial impairment of human rights as a result of a gross violation of human rights or as a result of an act associated with a political objective for which amnesty has been granted, end quote. Quote, a gross violation of human rights is defined as the killing, abduction, torture, or severe ill treatment of any person or any attempt, conspiracy, incitement, instigation, command, or procurement to commit, killing, abduct, torture, or severe ill treatment, end quote. The Act also provided for but did not require the creation of a President's Fund that would hold and disburse funds as reparations. The fund would hold and invest money appropriated to it by Parliament and money donated by non-governmental sources. Even though it addressed reparations, the Act did not codify or otherwise guarantee the right to reparations, nor did it grant the Commission power to implement any of the final reparations policy proposals. The Commission's power ended with the submission of the final report. And that will conclude tonight's reading of Chapter 15 of the California Reparations Task Force's final report. We ended on page 556. Our next reading will resume at the Committee on Human Rights Violations, CHRV, on page 556. Before you go, if you haven't done so already, please remember, like this video, hit the bell for reminders, and subscribe to our YouTube channel. When you go, please remember to get connected. Follow CJEC on all social media. That's Instagram, TikTok, Facebook, and Twitter at CJECOfficial. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and information on our Get Involved page. Get involved. Support our work by volunteering and/or donating. To donate, just click the Donate tab on the home page of our website. A special thanks goes to our amazing fiscal sponsor, the California Black Women's Health Project. Learn more about them at www.cabwhp.org. Thank you all so much for your time. I appreciate your patience. Thanks again to today's sponsors, the Plunkett children. Please remember, we are closer to reparations than we have ever been in California. Thank you and have a great night.